Yes, Mr.
Dear
Sethi.
Mr. Lordships.
Yes.
Lord, item 18, that is fixed for hearing.
Yes.
It is a contract matter.
Uh,
Ahead of this item, there are 2 items for hearing which are fixed. And not likely to reach today, and from tomorrow I am likely to be out station again.
okay.
So I have taken that answer from a learned friend. Let this matter be. Let it be after 2 weeks, Lordship.
Okay, Mr. Iralu. After 2 weeks.
Lordship.
Okay. He will be out of station. That is what he is saying. He will be out of station. On the prayer of Mr. C.T. Janvi, the learned senior counsel for the appellant, listed after 2 weeks. Yes. Yes, please.
Allow me to mention item number 5 and 6.
Item
Now,
5.
Yes,
Yes.
this is a reference matter made by the learned single judge in connection with the provisions for appeals from the courts of village council or TBs, etc. Now, Your Lordship, last year, the government has constituted a committee
Okay.
for framing of Nagaland Civil Code Act. Now, it is learned, I mean, from that, it is at the verge of completion.
Okay.
And the final draft is to be out soon. And once it is out, then it will be placed for approval. And if that is done, and if everything is covered, then they will settle everything.
But whether that Civil Code Act
Yes.
will have a retrospective effect.
Well, it may have,
That it may. You should be very sure.
yes.
Anyhow,
It has, because
if the act says it will have retrospective effect,
yes,
then yes, it will have.
yes,
But if it is silent, then it will be prospective.
Your Lordship. And as per the draft now, it is said that all the pending matters before the other courts, like DC or assistant to DC, it will transfer to the civil court side,
Okay.
regular court side.
Okay.
So if that is done, then the matters would be settled once and for all. So,
Okay.
because once a decision is made by this honorable court, then there may be some hardships. So if we can wait for that one first, we'll be very grateful.
I don't know whether that will have any impact on this case, but anyhow, it's all right. If you are seeking for adjournment on that ground,
Yes,
we can allow.
Your Lordship.
Okay, we allow. For what period? Adjournment?
4 weeks.
For 4 weeks.
Your Lordship, since after the final draft it will be placed before the appropriate authority, so instead of 4 weeks, maybe less, so 1 and maybe 3 months.
No, Mr. Iralu, let us see if during the pendency of this petition, the civil act is passed.
Yes.
Then we can adjust the case accordingly. Let us see. But initially, we give only for 3 months, 3 weeks.
Okay.
Okay.
4 weeks.
Okay. On the prayer of. This is item.
Item 5 and 6.
Okay. On the prayer of Mr. R. Iralu, the learned senior advocate for the petitioners in Civil Revision 6/2021.
Yes.
The matter stands adjourned for 4 weeks. Listed accordingly. Okay.
Oblige, Your Lordships.
Okay.
Please, Lordship,
Yes,
I'd like
ma'am.
to mention hearing item number 20. Lordship, if this matter may be adjourned till next week, since my senior is on station.
Your senior is Mr.
Tumpok Pangina.
Tumpok Pomonar. Okay. MS Senso submits that Mr. Tumpok Pomonar, the counsel for the petitioner, is out of station and therefore seeks adjournment of the case for a week. Prayer is allowed,
Lordship, there is an interim.
listed accordingly. Stop. The interim order passed earlier shall continue till the next returnable date.
Much obliged.
May I please, Your Lordship?
Yes, please.
Lordship, with the consent of the other side, I beg to mention item number 4 to discuss, Lordship.
Item number,
4, Lordship.
yes.
Lordship, in this matter, the union has filed a affidavit in opposition. We would like to file our rejoinder in this matter.
You are the counsel for the petitioner?
Yes, Lordship.
Okay. Mr. Senso, the learned counsel for the petitioner submits that he may be allowed 2 weeks' time. Okay, 2 weeks' time.
Lordship, may I pray for fixing a date, Lordship?
He may be allowed.
Can it be on 13th, Lordship?
He may be allowed on.
13th September, Lordship.
He may be allowed 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the Union of India. Prayer is allowed, listed on
13th September, Lordship.
13/9/2023. Okay.
Much obliged.
May it please your Lordship. Lordship,
Yes,
yes, to mention item number 19 for hearing, your Lordship. Corresponding number 2 for your Lordship. Lordship, I pray that the matter be posted after 2 weeks, your Lordship.
Respondent number
2 for your Lordship.
2 and 4. You are for respondent number 2 and 4?
Lordship.
Okay.
Yes, Lordship.
Mr. M. Solo, the learned counsel for the respondent number 2 and 4, seeks adjournment of the case after 2 weeks. Prayer is allowed, listed after 2 weeks. Okay.
May it please your Lordship,
Yes, please.
I beg to mention item 8. I'm speaking on behalf of my senior Joshua here.
Okay.
If your Lordship may kindly fix this matter after 1 week.
After a week,
Yes.
Mr. So-and-so makes a mention on behalf of Mr. Joshua Shakti, the learned counsel for the petitioner, and seeks adjournment of the case after a week. Prayer is allowed, listed accordingly. Okay? Yes.
Your Lordship, I would also like to mention item number 9.
Item 9.
Yes. Same prayer, your Lordship.
Okay, same prayer. Item 9, same prayer.
God bless you, Lordship.
Yes.
Please, Lordship,
Yes, yes.
I beg to mention item number 10.
Yes,
This habeas corpus petition has become infructuous
yes.
as during the detention, a fresh extension order has been
Yes.
passed. So I may be allowed to withdraw with the liberty to file a fresh.
Mr. So-and-so, the learned counsel for the petitioner submits that he has instructions to withdraw the petition as the petition has now become infructuous. Stop. Prayer is allowed. Petition is allowed. Petition is closed as withdrawn. Okay.
May I please, Your Lordship?
Yes, please.
Lordship, I beg to mention item 12.
Item 12.
Lordship.
Yes, what is your,
I may be given 2 weeks' time to file my affidavit in reply, Lordship.
to the affidavit in opposition filed by the,
State respondent.
Lordship, in that case, Your Lordship, the interim should be vacated because they have been seeking time and again to file the counter, but they have not filed the counter.
what is the matter about?
It's about they are challenging the advertisement of 56 posts of assistant headmaster as well as junior education officer. They are challenging the rules, Lordship.
Oh,
Yes, the violation of the rules, but they have no case, Your Lordship. Only the petitioner that is.
okay, we give them a grace chance.
Otherwise, Your Lordship, the school is running with difficulty
I know,
without the assistant headmasters.
We give you the last chance, okay? And next time, irrespective of whether you file reply or not, we proceed, okay? Mr. So-and-so, the learned counsel for the petitioner submits that he may be allowed 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed after 2 weeks. Stop. It is made clear that there shall be no further adjournment in the case, and the matter shall proceed on the next date fixed, irrespective of whether the affidavit in reply is filed or not. Listed accordingly. Okay.
Lordship, there is an interim, Lordship.
Stop. The interim order passed earlier shall continue till the next returnable date. Okay.
Much obliged. May it please, Your Lordship.
Yes, please.
Lordship, I beg to mention item number 11, Lordship. Dear Lordship, notice of service served upon respondent number 2 is still awaited, Lordship. So let this matter be listed after 2 weeks, Lordship.
You are the counsel for the applicant.
Yes, Lordship.
It is submitted by Mr. So-and-so, the learned counsel for the applicant, that notice of service of, that the notice of service upon the respondent number 2, upon the respondent number 2 is still awaited. And therefore submits that the matter may be listed after
3 weeks, Lordship.
3 weeks. Stop. Prayer is allowed. Listed after 3 weeks.
Much obliged.
Yes.
May I please, Lordship?
Yes, Mr. Vetu.
Lordships, I'd like to mention item number 14 on behalf of my colleague S. Mire.
Yes.
Lordship, I pray that this matter come after 2 weeks, Lordship.
Okay.
Yes, Lordship. Your Lordship, we have not completed the service upon respondent number 2 as well. So,
Okay, let's see the record afterwards. Let's see the record. Okay, let's see the record.
yes, Lordship.
Yes.
Your Lordship, I'd like to mention item 7 as well.
Item 7.
Yes, Your
Yes,
Lordship.
what is your prayer?
Your Lordship, we are here to file additional affidavit. 1 week time may be given.
Petitioner,
Yes, Your Lordship.
MS so-and-so, the learned counsel for the petitioner submits that she may be allowed a week's time to file additional affidavit. Prayer is allowed, listed accordingly.
Much obliged, Your Lordship.
For motion, item number 1.
My lord,
Mr. Allen,
yes, my lord.
I have been trying to understand your petition. But in spite of me going through the petition 2-3 times, I have still not understood what you are seeking in this petition.
Yes. Your
Secondly, will it be proper for me to take up this case? Because actually one so moto PIL is still pending. And actually some issues have been raised which is related to that PIL and in which I was the counsel for the government. That so moto PIL, what is that so moto PIL, Mr. So moto PIL regarding Kohima, Dimapur, yes. So I was just thinking as to whether it will be right for me to take up this issue when actually the issue, some of the issues raised by you regarding compensation were also actually like discussed in that PIL, where I was the government advocate.
Your Honor, yes, in my petition, Your Honor, Lordship has gone through, I understood. But there, the PIL which they have filed is different from the present PILs. So that's, I just want to make the justification also.
You are pulling the government letter dated, you are pulling the government letter of the year 2013, 14 and all this.
You know,
That is your annexure, some of the letters which is 2013, 14 and which, if I'm not mistaken, I have come across in that PIL.
my lord, if you allow me, I just want to.
No, if you allow me to hear, then it's all right.
The issue, what coming up, this balance, this is the present issue, which is very imminent and is very important issue. So this, I think, if your lordship is not in the position to take, being a counsel for the things, that is the another option. But my petition, what filing before this honorable court.
I have not understood your petition in any case. I have gone through 3-4 times. I have not understood what you are really which you are claiming.
Yes, Your Honor, my prayer for relief is mentioned in my prayer. And that column A to E, that is my prayer, my relief, what I seek for.
Yeah, process it, that's another mention. Because you're saying that 12, 13 matters,
Some letters
are there, no, next. So you can. Page 39 is there. Instead of dismissing another, filling this period can be dismissed.
Page 39 and notification, see, page 39, notification 11 November 2013. I think this was also put up in that PIL.
Your lordship, that is the land acquisition as per the.
If you feel that I should have no problem, I'll take up.
I don't have any issue if lordship consider my prayer to admit it, because the issue come up there, the issue come up, new issue, that is the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013. There are some new issue come up. The acquisition of land.
There may be some new issues.
Yeah, there are access of land and the damage of the property. There's so many things come up.
Exactly, that is what I am saying.
During the
You are claiming compensation for the excess land acquired, for the unacquired land.
Yes.
You are also seeking for protection.
Your
Correct?
Yes, lordship. And then there are so many uncut, which is block it and obstruct the landowners.
And in your petition, where have you stated who are the petitioners, whose properties have been destroyed?
Your Honor, there are
Have you stated?
Yes, Your Honor.
Where?
Yeah, Your Honor, the annexure 1 to 8, there are page number 26. They are the party.
No, they are the person who has been authorized to represent the aggrieved persons.
Yeah, Your Honor.
Who are the aggrieved persons?
The aggrieved person.
What properties were damaged? Where?
Yes. My lord,
Without any specification.
yeah, my lord, I'm coming to the prayer. The village.
I think, Mr. Anand, I will advise you, take proper instructions. Or at least consult some of the lawyers, those who are practicing in
Your Honor,
the High Court.
Your Honor, this is the issue.
I think this is not the way to file a PIL.
My lord, I'm just coming to the prayer. The prayers, the issue is that the village council.
Okay.
Village council.
Listen to me, Mr. Allen. Let us start reading from your paragraph 8, 9, 10, 11, 12, 13, and let us see what you have understood. Kindly make us understand. Let us see. Start from para 8. Let us see. And para by para you explain, because actually I have not been able to, I don't know about madam, I have not been able to understand.
The village council, the Gampra, who is representing the subjects of the village. Within the village, there's so many
See, Mr. Allen, we know that actually you are actually, the petitioner has been authorized by 8 of the village. And you have actually procured the authorization letter from the village council. That is okay. But what is the damage? Whose land has been damaged? Have you mentioned in your petition where it has been damaged? What properties have been damaged? Have you mentioned?
Yes, my lord.
Where have you mentioned?
My lord, I'm just mentioning in the prayer, when the joint verification comes, thereafter the actual course of damage will come. That is what my prayer, go for the joint verification.
No, see, I don't think this, when somebody's land has been damaged and they have to be compensated, it is those people who feel aggrieved, they should approach the court separately, not in the form of a PIL. Then they will look into the matter, whether their land has been damaged. You see, not in the form of a broad, simply a waiving PIL. I don't think that matter can be taken up that way. And concerning the security issues, I think the state government has taken appropriate steps, formed committees in this matter, isn't it?
Yes, my lord.
Based on the newspaper clippings,
My lord, the
some steps have been taken by the state government. So besides those steps taken by the state government, what is your grievance in the interest of the public at large? Not individual persons whose lands have been, they have been given some compensation. So you're praying for the additional compensation. So these people who feel aggrieved should approach the court, okay, mentioning the additional compensation that is required. Your form of PIL is very broad.
You're not.
And how can we just say compensate those when they're not even asking for compensation, these people?
My lord, in this
Additional.
PIL, for the compensation to the agreed party is mentioned for the joint verification. That is my prayer. And second point, there is land already acquired and they're uncut, which is disturbing and harassing the landowners. It is
Where is that land?
Yes.
Where is that land? Where has the damage caused? In which stage? Whose land has been damaged? I think at least this court has a right to know this.
Yeah, that lordship, for that I'm praying to this court to direct the concerned authority for the joint verification.
Are you joint verification where?
Where, what?
Directed by the.
No, you find out what is wrong. I think you should go to the place, see for yourself what is wrong, okay, where, which stretch, how dangerous it is. Then you come before the court saying it is like this, please do something. Just a sweeping statement will not do, because then the respondents won't know what to do, where.
See, we have many good lawyers in the High Court. Why don't you at least consult with them as to how to file a PIL?
Get the facts right, get the facts
Your Honor,
clear.
I also presuming to be a good lawyer. So my prayer is that.
If you are presuming yourself to be a good lawyer, we don't expect such a petitions. That is the issue.
So that is the prayer what I prayed. It is the wisdom of the court. I just trust and
If you
believe.
can withdraw,
So,
make
yeah.
a more.
Wisdom of the court may be.
We will allow you to withdraw with liberty to file. And then I think you will have to do extensive consultation. I think this form of, petition in the form of PIL may actually bring you to a situation which is not good for you in future, where all the parties are represented and then they start barking at you.
Your Honor, if the wisdom of the court decide that I have to go.
Yes, because actually, after going through, we feel that actually it may not be proper for us to actually entertain this petition in this form, Of course, you may have a right, but I think we will not be entertaining the PIL in this form. So I think you read through your PIL, just read through, because I have gone through 2-3 times and I have not understood. So Mr. Kame Alain Rongme submits that he may be allowed to withdraw the present petition with liberty to file afresh. Prayer is allowed. Petition is allowed to be withdrawn with liberty to file afresh. We are sorry, but we want you to do some more homework.
My lord is more or less.
Please, okay?
For motion, item number 2.
Yeah, please.
Yes.
Lordship, on last occasion, by order dated 19/7/2023, Lordship, my learned friend was requested to
Yes.
necessary instructions.
Yes, please.
Lordship, by order dated 19/7/2023.
Yes, yes.
This honorable court has directed the state respondent to come up with a necessary instruction.
Yes.
And also directed the Superintendent Central Dimapur to provide medical treatment, Lordship.
Yes.
We have provided a medical treatment, Lordship, to the applicant, Lordship.
Yes.
Lordship, so
What about the whether proper medical facility? Because actually, as per the medical certificate submitted by the Learned Counsel for the petitioner, I think he was in need of some medical treatment.
Lordship.
So what about that?
So, Lordship, to that effect, Lordship, the applicant, we have seek proper medical treatment to the applicant, Lordship. We have provided a proper medical treatment, Lordship.
Where is that? Where is the record? Let us see. See this?
This is dated. This is dated
Six.
before the order, no? 7/6.
7/6. Oh, there was 6/7.
After that, this, but this 27 referred to district hospital. That is the-
Your Worship, there are some records which have annexed in the IE also.
It's after this court order, no?
Which is that, please?
And this is 6 page
24.
27. Anything.
Has he been referred to district hospital? If you see the what do we call the prescription issued on 27/20/23?
From the district hospital, Dimapur.
Have you referred?
Lordship, in fact, this prescription was given by the district hospital, Dimapur, Lordship.
Which prescription? 27?
First page.
26/7/23, Lordship.
26.
Okay,
But
this is 26 after that, huh? The medicine has been given?
this is the latest prescription, Lordship, page 1.
Oh. Okay.
Nothing has been stated here. It is only prescription.
Apart from the prescription for the medicine, there's no medical report.
Where is the report?
It's not your option. In the latest medical prescription also, nothing has been stated.
Well, any report?
No, Lordship. This is the only instruction that I received from the superintendent Central Jail, Dimapur, Lordship.
So how do we decide on the basis of this prescription?
Lordship, that is the problem, Lordship. Since as directed by this honorable court on 19/7/23, Lordship, on 20/27/23, Lordship,
But in fact, you were supposed to actually at least get this information. You have not come with these instructions?
Lordship, as directed by this honorable court on 19/7/23, Lordship, on 27/23, Lordship, Senior Medical Officer, Central Jail, Dimapur, took a proposed medical treatment, Lordship. And thereafter, Lordship, on 24/7/23 also, Lordship, biopsy as well as a biopsy was also taken. Proper treatment was taken, biopsy and all those things were taken. And thereafter, Lordship, on 26/7/23, Lordship, the applicant was giving a treatment as well as with proper medication, Lordship. So this is the latest status as of now, Lordship. Till date.
No, there's specific information as to whether proper medical facilities are available within the state for treating the applicant. What about this?
Lordship, but however, Lordship has also directed, this honorable court has also directed to go for, to give a proper medical treatment, Lordship.
That
To that extent, Lordship, we have done, Lordship.
No, but what about the other instructions?
Lordship, in that view of the matter, Lordship, if Lordship may please to pass a certain direction, Lordship, and Lordship on the next tenable date, Lordship, we may able to.
The direction is already there. Only thing is that you are not carrying it out. Direction is there.
As far as medical treatment is concerned.
What is your latest information?
Lordship, the latest information also, Lordship, what I received from the family of the accused. Lordship, he was taken to the district hospital, and as per the report given by the doctor, his diabetes is too high. So first of all, the diabetes has to be controlled. Thereafter, only the surgery has to be performed. That was an instruction I received. But as per the report produced by my learned friend, Lordship, except the prescription from medical, there's no medical report.
Medical report was given to the family members?
No, the petition is in confinement. The accused is in confinement.
No, that's why. Whether actually that medical certificate.
No. Even the accused was taken to the hospital by the jail authority.
Huh? So you are saying that this document submitted by the learned PP
Incomplete.
is not all the documents. There are other documents?
I don't think it should be, but
How do you say it's incomplete?
verbally, you were informed that his diabetes has to be controlled first. Thereafter, only the surgery has to be done.
You get his instruction and come.
Lordship.
Okay?
Whether the proper treatment can be
Yes.
given through jail, and the jail also they give proper treatment. They take them to district hospitals, I think. Surgery is preferred also.
Mr. Lima Wabang, the learned counsel for the applicant, and Mr. Vijmomi, the learned PP for the state respondents. Stop. By the order dated 19/7/2023, the learned PP was directed to place the necessary instructions of the case before the court. Stop. It was also directed that the learned PP shall come with necessary instructions as to whether proper medical facilities are available within the state for treating the applicant. Stop. It was further directed that the Superintendent, Central Jail Dimapur, shall provide proper and necessary medical treatment to the applicant as and when required. Today, when the matter is listed, Mr. Vijmomi submits that as per the direction given in the order dated 19/7/2023, the applicant has been provided the necessary medical treatment and support by the Superintendent, Central Jail Dimapur. Stop. Mr. Vijmomi has also placed certain medical records showing the treatment afforded to the applicant. Stop. From the medical records submitted, we are not able to understand as to whether proper medical facilities are available within the state for treating the applicant. Stop. The learned PP shall therefore, as ordered on 19/7/2023, come with specific and definite instructions as to whether proper medical facilities are available within the state for treating the applicant. Stop. It is made clear that the Superintendent, Central Jail Dimapur, shall continue providing necessary medical treatment to the applicant as and when required. Listed on, listed after,
Not week, Lordship. Next week.
After 2 weeks, Lordship, so that we will get a proper instruction, Lordship. Since
okay?
Lordship, the petitioner is suffering from pain.
Okay, listed after a week for enabling the learned PP to come with proper instructions as directed.
On 16.
Listed on
16. $16. It'll be after 1 month.
On 17 Lordship, since 15th of the
16th is Wednesday.
TP 16.
Okay, listed on the 17th. 17/8/2023. A copy of this order shall be given to Mr. B. Jimomi, the learned PP.
For motion, item number 3.
Mr. Lordships,
Yes.
I have instruction to appear on behalf of the respondent, Lordships.
Here there is a delay of 37 days in filing the connected appeal.
Are you filing any objection or are you allowing the petition?
Lordship, as far as I is concerned, Lordship, I have no objection, Lordship.
Okay. What have you explained?
Lordship, paragraph 3, 4. Because of interdepartmental communication, Lordship.
Had MSV Sokri, the learned Additional Advocate General for the applicant. Stop. New matter. This application has been filed under Section 5 of the Limitation Act 1963, seeking for condoning the delay of 37 days in filing the connected appeal, which is for quashing and setting aside the impugn order dated 1/5/2023 passed by the learned single judge in WPC number 318/2021. Stop. The grounds for the delay. The grounds explaining the delay has been set out in paragraph 3 and 4 of the application. Stop. We have perused the application, explaining the delay, and we are satisfied that the applicant has been able to satisfactorily explain the delay. Stop. We accordingly condone the delay of 37 days and allow the applicant to file the connected appeal. Mr. Supungwati, the learned counsel for the respondent, appears and submits that insofar as the delay is concerned, there is no objection. Stop. Application is allowed. Delay condoned. In the writ appeal, na?
Lordship, I'm praying for stay of the impugned order also. Because here, Lordship, the petitioner, he is a ward charge employee and he was released on service in the year 2014. And in the year 2015, he died. And after his death, his wife approached this court asking for regularization of his watcher service. Petitioner does not come within the purview of the policy of the government because at the time of his retirement, he stands at serial number 17. So, Your Lordship, even the present case is currently covered by the apex court passed in state of Nagaland versus Nishivi. But with utter regard to the decision passed by the apex court, the learned single judge relied on the division bench. That was a judgment that was passed in the year 2015 and directed the state respondent to regularize the petitioner. So, Your Lordship, there is a gross illegality because any decision passed by the Supreme Court is binding on all the courts, Your Lordship.
Heard MS Visokri, the learned additional advocate general for the appellant, and Mr. Subhangwati Jamir, the learned counsel for all the respondents.
Yes, Lord.
For all the respondents. Stop. Appeal admitted. Fixed for hearing on when?
Lordship, after 3 weeks, Your Lordship.
Fixed for hearing after 3 weeks.
Yes.
In the interim, the order, which order?
Lordship, order the
Which page?
By Lordship, that is page 10. I-88, that is page 10.
Oh, you have filed another IA?
Yes, for stay, yes, Lordship. The order dated 12/5/2023.
Appeal admitted, okay. Fixed for hearing after 3 weeks. Then in IA, which one? 88.
Page 10.
Heard MS Visokri, the learned additional advocate general for the applicant, and Mr. Subhangwati Jamir, the learned counsel for the respondents. Stop. The application has been filed for stay of the order dated 1/5/2023 passed by the learned single judge in WPC number 318/2021. We have heard, stop, the learned counsel for the parties. The order dated 1/5/2023 passed by the learned single judge in WPC 318/2021 shall remain suspended till further orders.
For admission, item number 13.
Please, Your Lordship.
Yes. Return service report
I received instruction to accept notice on behalf of the respondent number one. For the counsel for the appellant is absent.
Respondent number one?
Yes.
Okay. Who is for the petitioner?
Appellant for the SBI.
Where is YP Gupta?
He's absent, my lord.
The learned counsel for the appellant absent. Stop. Mr., your good name? So and so. Appears for the respondent number one. Listed after. You want to file your affidavit?
Maybe 1 week.
Appears for respondent number one and submits that. He may be allowed 2 weeks' time to file affidavit in opposition on behalf of the said respondents. Prayer is allowed, listed after 2 weeks.
For orders, item number 14.
I think this has been, mentioned.
I've mentioned, they've mentioned it.
be taken up. You wanted to see the documents.
Oh. What happens? Mr. Senti Yama?
Yes, they mentioned, and then we said we'll let it be taken up internally. So we have to wait.
Yes, ma'am, applicant have not taken steps. Okay?
There's a counsel for the applicant.
Office note dated 7/8/2023 shows that the applicants have not taken steps for service of notice upon respondent number 2. So the applicants are accordingly directed to take steps for service of notice upon respondent number 2 within a period of 7 days from today, listed after 2 weeks.
For orders, item number 15.
Yes, Mr. Yamawati.
What is the kind of steps for using this?
Steps for?
On the source one.
Who is the respondent?
How Srimati Nanda Kumari.
What is the matter about?
This is an petition. It's relating to order of cake.
Against the?
Order of cake.
Okay, okay.
Whereby the termination order has been passed and sent.
Okay, so you are challenging the order of the gate.
No.
Have you taken steps for?
Yes, I will. I will suppose.
When did you take that step?
On 13/7.
Where is await? Awaiting service of notice on the sole respondent. List the keys after 3 weeks. Let us give at least a chance to that person, okay?
The interim order will be considered in the next.
The interim order, the prayer for interim shall be considered on the next returnable date. Okay.
For hearing, item number 16.
Ma'am, will it be convenient for you? Hearing? Yes, I do.
It'll be difficult because the DB is going to sit on
Will it be good?
Yes, the mic is.
I think, yes, DB will be here only today. Can we take a chance next week for 2 days? We will fix it on Tuesday, Wednesday.
My lordship, I am not available. I have other matters subjects to my lordship.
Yeah, you should make your.
Today I will have only simple. I not take much more time. Only have to be argue the one point and legal point person. It is my argument. My lordship only the 5 minutes time. My lordship has permit.
Come next week.
My lordship.
Next week we'll give you sufficient time. Today,
Otherwise, I'll fix on 6th September. My lordship. One more matter is fixed. My lordship.
similar matter.
Other related matters, same.
It's listed on 6th.
6th of September.
Yes, Mr. Jimomi. Is it convenient for you?
It's all right, my lord, but if your lordship, if my lady is sitting today, perhaps you could even finish it. What matter? Can we try today?
Okay. Let's see. What is this CRAP?
My lordship, this appeal against the granting bail to the two appeals will concern connected appeals, my lordship. Item number 15 and 16. That is appeal number A4 and A1 in the trial, my lordship.
Same order, your lordship.
Same order. This is a common
The two
order.
accused.
Bail was granted to the accused person, so it's against the bail.
So I think you will be more convinced. Then, what is that? Please call it. Let's go out and come. Let's go. 2, 3 minutes.
Okay.
After 2, 3 minutes. Yes,
Lordship can come 9 to 6 or September 9. The unfriend has take more time. They are
6 September.
6 September.
Is the age bomb?
It is my application and the
No, is it convenient for you?
it's all right.
Okay. On the prayer of your good name, Mr.
Satyanand. Satyanand.
Oh, I'm sorry. There are item 16 and 17. 16 and 17.
Yeah, 16, 15.
16 and 17, no? 16 and 17.
16 and
On the
17.
prayer of Mr. Your good name?
Satyanand.
Satyanarayan. Satyanarayan. The learned
Senior PPN.
senior PPNIA. The matter stands adjourned on 6
6
9
2020.
2023. Okay.
For hearing, item number 21 to 22.
The petitioner is a Warchurch employee.
Give us the gist.
Yes, so your lordship, the petitioner, he is a Warchurch employee. He was released on 31/7/2017. 31/7/2017. Then he approached this court for regularization of his Warchurch service. So
When?
In 2020.
2020.
Yes. So in 2020, and the learned single judge, he erroneously misinterpreted the central
CCS pension rules.
CCS pension rules 1972, and he directed the state respondents to regularize the petitioner's service 1 day prior to his retirement and to pay the pensionary benefit. So, your lordship, this division bench of this
All the read
it's
appeal.
by accomment judgment.
All the read appeal, I think these are different facts, no?
No, everything is similar, your lordship.
Date of appointment,
Date of appointment are
the
different.
post where actually he or she was appointed, everything is same.
The date will be different, but in the same department, executive engineer Kifiri.
And same date of retirement, different. So the facts are different.
Yes, only that one. Otherwise, it was passed by a comment order, your lordship.
Comment, okay.
judgment and order, your lordship.
Okay,
Yes.
okay.
So, your lordship, I may be allowed to produce the recent division bench of this honorable court.
Justice Suman Shan.
Yes, yes.
Yes.
But before that, your lordship, I may be allowed to take you to the judgment, the impugn judgment. The impugn judgment, that is at page.
You are referring to which will be your lead petition? Which will be your lead appeal?
31.
31.
Yes.
Why not 30? Since 30 is
Yes, 30.
so from 30.
Okay. Our lordship may come to page 48. This is the common judgment reported in the 7/9/2020.
Page
Page 48. Page 48.
38.
48. 48.
Oh. But the judgment is page 38.
start at page 38, yes. And the operative part is at page 48. So, Your Lordship, page 48, I may take you to para 8. Apparently, there is no dispute with regard to the service condition of the petitioner, since each of the petitioner has been superannuated by the respondent number 3, showing that they have under continuous service for more than 30 years. The CCS Pension Rules 1972 clearly provides that such category of employees as the petitioners are entitled to pension after continuous service of 10 years. It has already been clarified by the learned CGC that CCS Pension Rule 1972 has been adopted by the state government. Therefore, there is no further need to issue notice upon the respondent number 1 to 6 to clarify the matter of the issue, but to dispose of the matter in the interest of justice. It could only cause delay. The present cases are further clearly covered by the cases mentioned by the learned counsel for the petitioner in such and such. Having considered the entire report, this court is of the view that this page of writ petition have merit and relief may be granted. I propose to dispose of this page of writ petition by a common order at the motion stage, considering it to be a covered case and having undeniable merit. The respondent number 3 shall take steps to give pensionary benefits to all the above 3 petitioners by regularizing their services 1 day before the date of their retirement. The respondent number 3 shall also make all effort to complete such exercise within 3 months of the passing of this order. With the above observation, this page of writ petition are disposed of. So, Your Lordship, the only grounds for allowing the writ petition is by the learned single judge is that he erroneously interpreted that the CCAS pension rule is applicable to the war charge employees, and he directed the respondents. So, what the learned division bench of this honorable court says about the CCAS pension rules? Yes, that is at page 16.
Page 16.
16 of the judgment which I produced, Your Lordship. Page 16, para 16.
Just wait, okay? Yes.
Yes. Para 16, as has been observed here in the above, the claim of the respondent for receiving pension does not come within the scope and ambit of the Act of 2001. Although Mr. Lonchar has placed heavy reliance on the provision of rules of 1972, so as to contend that the respondent is entitled to receive pension. The fact remains that, as per Rule 2B of the rules of 1972, person in casual and daily rated employees have been excluded from the purview of rules of 1972. As such, the respondent clearly does not come within the ambit of the Act of the Rules of 1972 for making out a case for payment of pensions. So, Your Lordship, even in the present case also, the petitioner, they do not come under the government policy. Because, yes, because they are not the senior most, they are enjoying a
See, before you proceed, no?
Yes.
Tell us the petitioners,
Okay.
their date of joining,
Yes, Lordship.
how were they appointed.
Lordship.
You're coming to the argument straight away.
Yes,
Just
yes.
give us a background of
Okay,
the facts.
Lordship.
No?
Yes.
I think in page 45 of the judgment,
Yes, Lordship.
who are there. Instead of coming to the argument straight away, these are the petitioners. They were appointed on this as what? We're not even sure what were they appointed as, because you're coming to your judgment straight away.
But case, I just give
You
a
are-
slight
yes,
gist
yes.
of, yes, Lordship.
Let us come.
There's some background of the case.
WA 30, let us come.
Lordship.
In WA
All
30.
the date of this appointments and all that is mentioned in page 45 of the judgment.
So all these 5 are the petitioners in the different WAs, is
Yes,
it?
but Your
Okay.
Lordship, the state is not challenging the respondent number 3.
Okay.
Yes, because after the after
Respondent, who is respondent number 3?
not the serial number
Serial
3,
number
serial number
three.
3. Because after the disposal of the case, he was still in service and he came within the purview of the of his memorandum, so his service was
2015.
regularized. But whereas the other persons, they were not regularized. Appeal was preferred against the order, Lordship. So, Your Lordship, Sojiba, he was appointed in the year 1984. Then he was made to retire in 2019.
Yes, wait. Kindly take us to your petition paragraph. Which paragraph we are reading about the particulars?
About the writ appeal 30 at page 45. In the common order, Your Lordship, there was a charge of
At page 45.
Yes.
Now, in your, take us to your writ petition.
This is to the writ petition, Your Lordship.
You have not enclosed the writ petition, the affidavit in opposition file.
Your Lordship, it was disposed at the motion stage. Because the learned counsel,
What about the writ petition?
the writ petition starts at page 13.
13. Let us see that. Let us at least have a glimpse of the particulars.
Yes. So page 25 is his ID card, which he was first donating the office in the ID card. Page 25, 1884. Then in page 26.
Miss Okre, kindly take us to the particulars. Where have you stated that he was appointed on so and so date, he was working at so and so? Where are those?
Lordship, at page 18 of the writ petition.
Take us to that so that we can at least have a glimpse of that. Para, the petitioner joined service, yes, okay.
Was a fixed pay of such and such, however, initial appointment of the petitioner could not be traced out in the office and the petitioner personal copy was also misplaced. Whereas it was recorded in the office order and the identity card issued by the department with such and such that the petitioner was appointed on 18/8/84. Yes. This is the statement of the writ petitioner. Then the motion will come to
That the petitioner continuously
served the department for 25 years. That is what the contention of the petitioner, Lordship. So his release order is at page 26.
was he paid salary or scale or was he paid
He
fixed?
was on fixed pay, Lordship.
That's why it shows all those things. That shows all those things. You should understand that the court is expected to know the law, not the facts.
So your Lordship, page paras 3 says that he was a fixed pay. That the petitioner joined the service on such and such with a fixed pay or such and such.
Until your retirement, you were getting 350.
That was his initial.
That was my initial.
Then at the time of retirement, what were you getting? Have you stated anywhere?
Regarding about his payment, he is not contending on that. He is only
No, but he is not contending, but it is our right to know. That is, we have a right to know what are his particulars. I've told you, you are expected that the court should know law, not the facts.
My lord, I have not mentioned in the writ petition. I was receiving 5,000.
Okay.
So he is on fixed pay, your Lordship.
Yes, ma'am.
So It does not come under the policy of the government of Nagaland. So he has approached this court only on the grounds of the CCS pension rule. That is his only prayer. That is at page 20, Lordship. Page 20 of his writ petition. Para 11.
And your contention on the CCS pension rule is that he is not entitled under the 1972 rules.
Yes.
Why?
Because, Your Lordship, in my page 57, I have annexed the Central Civil Service Pension Rules.
In page?
57.
Page 57.
Yes. Page 57. Application safe as otherwise provided in this rule shall apply to government servants, including civilian government servants in the defense services, appointed substantively to civil services at post, in connection with the affairs of the union which are both of pensionable establishment, but shall not apply to number B, person in casual and remunerated employment. So, Your Lordship, here the petitioner is not a government servant, Your Lordship. And even the Central Pension Service Rule clearly says that it does not apply to a person in casual and deregulated employment. So, the ground on which the petitioner approached this honorable court was on the ground that CCS pension rules applies to him.
Okay.
Yes. So, Your Lordship, the CCS pension rule was is never applicable to a war charge employee. That is the settled law passed by the division bench of this honorable court. So, Your Lordship, in that view of the matter, Your Lordship, the appeal may be allowed, and the writ petitions WPC 100 of 2020 be dismissed and flush and set aside the order dated 2nd 9 2020. That's my prayer. Except all the, it's like the year of appointment will be different. Otherwise, Your Lordship, everything is the same. It is mentioned at page 55.
Finish your appeal.
Because it's already covered, Your Lordship, by the division bench of this honorable court.
So the judgment of this single bench says that the CCS pension
Yes.
rules is
Yes.
applicable in the state of
Yes.
Nagaland,
Yes.
isn't it?
It's applicable in the state of Nagaland, Your
Oh.
Lordship, but it is not
Based on that.
applicable to the war charge employees. Yes. Yes, we followed the CCS pension rule. We adopted that, Lordship.
Yes, Your Lordship.
But what about the other direction to regularize the service within a day ahead,
Lordship,
1 day ahead,
yes, one
before the
day-
date of his
when-
retirement?
Your Lordship, when he does not come under the policy of the government for regularizing, where is the question of regularizing his service? And in order to regularize his service, there should be a law which gives pension. So when the Central Civil Service pension does not applicable to the war charge employees, the question of regularization does not arise, Your Lordship.
Which OM you are banking?
Lordship,
2004 or 2015, which applies?
even 2004 and 2015 also, Your Lordship.
No, in some cases 2004 will not apply. In some cases. Suppose if 2004 was in operation when that person was in service and he retired he retired when 2004 OM was in operation, then in that case 2004 will apply. But suppose if he retires when after 2015 OM comes into force.
Lordship, the 2015 it talks only about the work charge employees enjoying scale of pay. But here in the present case, the petitioner is a fixed pay work charge.
When did you retire?
In 2019. So the 2004 applies to him. But he is not the senior most work charge employees. That's why service could not be regularized. So the petitioner also knew that he does not.
Why not 2015?
2015 talks about only of the.
Read the scheme. Read the scheme.
The scheme talks about.
Read the scheme. Let us come to that.
Lordship, since it is not applicable here, Lordship, that is at page 52. It's very clear.
Don't jump things, oh, don't jump things.
Page 52.
52.
Yes. Office memorandum dated 17 March 2015. On due consideration of the report of work charge and pension employee commissions and in compliance with the judgment and order of Honorable High Court, the Governor of Nagaland is pleased to introduce the following schemes for regularization and absorption of work charge and pension employees.
Read the number one.
Number one is all existing work charge and casual employees of various departments who are enjoying scale pay and who have completed 30 years or more continuous service as on 1/1/2015 will be regularized by conversion of the post into regular ones personal to them and subject to security.
So why it should not apply against him?
Because he is not enjoying scale of pay.
That's why he's not enjoying scale of pay, but the OM 2015 is equally applicable to
No,
you.
Your Lordship, it talks about only the word, only who are enjoying scale of pay and who have completed.
Miss Sokre, are you understanding, are you following what I'm saying?
Lordship, I follow what you are asking.
Yes, I am saying that this OM is against him and it is applicable to him. That's what I'm saying.
It is not applicable to him.
Arey.
This OM is not applicable to him, Lordship.
It is applicable to him in the sense that he cannot enjoy this because he's not having scale of pay.
Yes, he is not scale of pay.
That is right.
Because he's not having scale of pay,
yes,
okay, he cannot enjoy.
Yes.
So this OM is applicable to him.
But it will not cover
way.
him, negative. That is what they, please understand.
Yes.
Don't howl, understand.
So Your Lordship, here this
So
OM.
I am saying this is, he retired in the year 2019.
Yes,
This OM was actually formulated in the year 2015.
yes,
And it speaks about all existing work charge. He is a work charge employee, correct? He is a work charge,
yes.
just answer me, he is a work charge employee.
Yes,
But this regularization, this OM says all existing work charge employees who are enjoying scale of pay and in service for 30 years
yes, Lordship.
shall be eligible to be regularized.
Yes, yes.
Correct.
Yes.
That is why I am saying this OM is applicable to him, but negatively he will not be regularized under this OM because
Yes.
he is not enjoying scale
Exactly,
of pay.
Lordship. Yes, yes, yes. So the petitioner also he.
So you are actually making a submission that this OM is not applicable. I am saying that this OM is applicable, but it is against him.
Lordship. So Your Lordship, the petitioner knew that he does not come within the two OM, that is the OM 2004 and the OM 2015. So he approached this court basing on the CCS pension rules only, asking for regularization of his service. So Your Lordship, the learned single judge, he had erroneously interpreted the CCS pension rules and says that it is applicable to the petitioner and directed the state to regularize his service. So, Your Lordship, that directions, it's illegal, Your Lordship, because it is impermissible in law, and it is impermissible to...
Which OM did the single judge?
The single judge did not rely on the OEM, he just relied on the CCS pension rules, Your Lordship.
And in the writ petition, on which OM you relied?
My lord, I rely on the order of the single bench.
No, in your writ petition, in which OM did you rely? OM 2004 or 2015?
No, my lord. He is not relying on anything, Your Lordship.
Then, if you are not relying on any of these OM,
So he is only relying on the CCS pension rule, saying that it is applicable to him.
if that is your case, I think.
My lord.
Then why have you annexed all this OM? If you are not relying.
No, just the annex of
The annex are annex, Your Lordship.
So let us at least let us see your writ petition. Let us see your writ petition. Let us see your prayer. Where is that?
Writ appeal.
No, writ petition.
The period is
In the writ petition.
page 22.
Page 23.
Yes. Page 23.
Yes,
In
okay.
the premises aforesaid, it is respectfully prayed that Your Lordship will graciously be pleased to admit this petition, call for the record, issue a rule calling upon the respondent to show cause as why a writ of certiorari and or mandamus or any other appropriate writ, order, or direction should not be granted, and upon cause of causes being shown, be pleased to make the rule absolute in the following term. Direct the respondent to grant posthumous regularization of the service of the petitioner, and to grant all pensionary benefits to the petitioner in terms of the rule, and or pass any such further or order as Your Lordship may deem fit and proper in the facts and circumstances. So,
My
Your
lord,
Lordship,
here in the prayer portion, I've made the correction here. It's written posthumous regularization, but in the main court order, I've made a correction with the permission.
What correction was made?
Here, posthumous, I've given a posthumous regularization,
Yes.
but posthumous has been removed.
or whatever be Your Lordship.
If posthumous is removed,
Yes.
then your case becomes worse. So you had actually filed the writ petition without relying on any of the two OMs.
Yes, my lord.
You did not rely on any of those two OMs.
No,
We
my lord.
rely only on the CCS pension rule. So that is mentioned at page 20, paragraph 11.
Paragraph
11
of his writ petition.
of his writ petition, Your Lordship. Page 20, paragraph 11. So he is relying on the CCS pension rule, the government of India's order.
Page
20, paragraph 11 of the writ petition. It says that moreover, the Central Service Pension Rule 1972 clearly laid down Rule 2, grant of pensionary benefits to temporary government servant retiring on superannuation, invalidation, or completion of 20 years, now 10 years temporary service one. In terms of Rule 2 of the CCS Pension Rule 1972, a government servant, including civilian government servant in the defense services, appointed substantively to a civil service of post-pensionable establishment is eligible for the grant of pension and that come retirement gratuity. A government servant who, at the time of retirement from service, does not hold a lien on a permanent pensionable post is not eligible for pension and that come retirement gratuity, but is eligible for terminal gratuity under Sub-Rule 1 of Rule 10 or Sub-Rule 1 of Rule 11 of the CCS Temporary Service Rule 1965. The questions of grant of pension to government servants who retire after a long years of service without being confirmed in any post has been under consideration of the government. It has been decided that a government servant who in his retirement from service on attaining the age of superannuation or on his being declared to be permanently incapacitated for further government service by the appropriate medical authority after he has rendered temporary service of not less than 20 years, now reduced to 10 years, shall be brought within the purview of CCS Pension Rules 1972 and the condition holding a pensionable post in a substantive capacity shall be dispensed with in his case. Consequently, such a government servant will be eligible for the grant of superannuation or invalid pension that comes retirement gratuity and family pension in accordance with the provision of the aforesaid rules. So, Your Lordship, he is relying on this, thinking that if the person served for now 10 years, he is entitled to pension. That is what the uh, prayer of the petitioner. But if we read this, it talks about a government servant. So the petitioner, who is a work charge employee, is not a government servant. And here in this office, Government of India orders talks about a confirmation of service of his service. So Your Lordship knows that once a person is appointed, he will be on probation, and after that his service will be confirmed. So it does not apply to the work charge employees. So the division bench of this honorable court has also rightly pointed out that the CCS pension rule does not apply to a work charge employee.
Let us see what was the fighting of the learned single judge on this. Which is the page? Impugned judgment? 48, na?
We may read the para 6 also. On query as to whether the CCS Pension Rules 1972 is applicable to the state of Nagaland, the Learned Council has clarified that CCS rules, once it is put in place, has to be applied by the state. Further, he has clarified that the state of Nagaland has adopted the CCS Pension Rules 1972. Although he is unable to give the exact date when the rules was adopted by the state government for its application, I have considered the report placed before me and also the submission forwarded by the parties. Apparently, there is no dispute with respect to the service condition of the petitioner, since each of the petitioner has been superannuated by the respondent number 3, showing that they have been under continuous service for more than 30 years. The CCS Pension Rules 1972 clearly provides that such category of employees as the petitioners are entitled to pension after continuous service of 10 years. It has also been clarified by the learned CGC that CCS Pension Rule 1972 has been adopted by the state government. So even here, the learned single judge has also misinterpreted the CCS Pension Rule and saying that despite of the petitioner being a work charge employee on a fixed pay, if he served for 10 years, he will be eligible for pension under the CCS Pension Rule. And he directed the respondent to regularize the service of the petitioner 1 day before the date of
So this order was passed without issuing notice to the government.
Yes, it was disposed at the motion stage, Your Lordship.
That means notice was not issued to the government.
Yes.
And just tell us the reason why notice was not issued. Page 49, the next paragraph. Continue. Second paragraph.
Second, the present cases are further clearly covered by the cases mentioned by the learned counsel for the petitioner in such and such. Having considered the entire report, this court is of the view that this bench of writ petition have merit and relief may be granted.
Where are these citations? WPC 96, WPC 104, WPC 105. Where is the citation? Is it enclosed?
Yes, my lord, it's enclosed.
It's enclosed in the petition?
Yes. Lordship, page 50.
Page 30, okay.
Page 30, then it's a common judgment, Lordship. So the operative part is at page 37.
37.
Yes, operative for 37 para 9. In the facts and circumstances of this case, this court is therefore to consider opinion that the state respondent should reconsider the case of the petitioner's appeal. Accordingly, this petition is disposed of with a direction to the state respondents to consider the case of the petitioner for regularization of the services only for the purpose of paying pensionary benefit and thereafter pass appropriate order. So, Your Lordship, the order which the single judge relied on and give a direction, if we read properly, it is only a direction to consider the case of the petitioner, not a straightaway direction. So with this, Your Lordship, I have given in my terms at page 9, in my point number 8. Page 9 of my appeal. Point number 8. That the learned civil judge has observed that
Your page
page 9
of your?
of my appeal memo. Page 9, paragraph 8, Roman 8. The learned single judge has observed that the case of the petitioner is covered by the judgment dated 27/3/2015, passed by this court in such and such. It is submitted that no relief was granted by the Honorable High Court in the relied upon judgment. The relevant extract of the judgment is reproduced here in below. I don't need to read, since I read before. It is submitted that in the relied upon judgment, the direction was given to the state to consider whether the petitioners can be regularized. There was no decision or direction to the state to grant pensionary benefit, and the direction was left to the state government. So, Your Lordship, if we see, there was only a direction to consider only. There was not a clear direction to regularize them. Whereas in the present case, we relied on the judgment on the CCS pension rule erroneously, and he has directed the state respondent to act contrary to law. Lordship. So the impute judgment and all the data.
Where is that Nishevi's case? Is it a part of your record?
Yes, yes.
Where is that?
Your Lordship, it starts on page 58. 58 and the operative part would be at page 62. 62, para point 41. For one, it is required to be noted that the deceased employee died in the year 2005. During his lifetime, he never claimed any regularization. That the respondent here in original petitioner, wife of the deceased employee, claimed the regularization after a period of 12 years from the date of the deceased employee. At the time of the death of the deceased employee, he was not entitled to regularization as he was much below in the list of the work charge employees whose services were to be regularized. Under the regularization policy, the services of the work charge employees were required to be regularized as per the seniority and as and when the vacancy arises. The services of the other work charge employees, even who were senior to the deceased employees, were regularized in the year 2009, after the death of the deceased employee. Despite the above, the High Court has directed the state to regularize the services of the deceased employee 1 day prior to his death, which otherwise his services were not required to be regularized, as his turn had not come and he was much below in the seniority list. 4.2. Considering the aforesaid facts and circumstances, the impugned judgment and order passed by the High Court is unsustainable, and the same deserves to be quashed and set aside. 5. In view of the above and for the reasons stated above, a present appeal is allowed. The impugned judgment and order passed by the division bench of the High Court as well as the learned single judge is hereby quashed and set aside. Consequently, the original writ petition filed by the respondent were here instance dismissed. However, in the facts and circumstances of the case, there shall be no order as proposed.
Okay, madam.
Yes.
If you are saying that actually 2004 OM applies to him,
Yes.
where have you stated that he was not the senior most?
Lordship, page 7, para 2. petitioner do not come under office memorandum dated 2015 as he is not enjoying scale of pay as on that second side. The writ petitioner also do not come under office memorandum dated 2004 as during the petitioner's service period he is not the senior most for charge level. As such, his service could not be regularized till the date he was superannuated from service. So, Your Lordship, when during his period of service, when he is not entitled to regularization, Your Lordship, relying on the CCS pension rule, which is not applicable to the petitioner, could not make the petitioner to be regularized in service. So, my prayer is that there is a gross illegality in the impugn judgment in order dated 7/9/2020, but by the learned single judge, by the commune. So, Lordship, my prayer is that the appeal may be allowed and the judgment and order be set aside and quashed and the writ petition be dismissed.
Yes, please.
Now, if you come to page 45 of the judgment of the single judge,
Yes, Lordship.
now this table is given and you're saying the serial number 3.
Yes.
You're saying he's been regularized. Is it serial number 3?
Yes, yes, yes. So
On
we are
what
not-
grounds? On what grounds has he been regularized? When his date of retirement?
No, Your Lordship, this is what at the time of filing of the writ petition, the petitioner, it is from the documents of the petitioner that he was retired on 2019.
Oh.
But no notice was served to the department. No notice of the writ petitioner was served to the government, Your Lordship, the department. So this person, the petitioner has wrongly made a mention that he retired on such and such day. But while going through the report, he was not supposed to be retired on 2019.
Okay, so this date of retirement is wrong, what has
Yes,
been given.
yes,
Okay,
yes.
because
So-
he still stands on the same footing, so I was wondering how he has been regularized
Yes,
while
he has
his
been
friends.
regularized, Your Lordship.
Because his date of retirement is not correct, what is given
He
here.
was
It was
still
in-
in service
Okay.
at that point of time.
Okay.
But whereas the other petitioner, they were already retired from service, Your Lordship.
So this table is wrong, serial 3 is wrong.
Serial number 3.
Yes.
So what is given here, it's wrongly
Yes,
reflected.
and with regard to serial number 3, and we are not challenging.
Okay, okay, he's not one of
We
the
are only
petitioners.
filing a secret against serial number 1, 2, 4, and 5.
But since you mentioned that he's been regularized, I was just wondering how has he been
Yes, yes,
regularized?
yes,
Okay,
yes.
fine.
Yes, my lord chair, the serial number 3, his retirement release order was actually released, given to him by the department.
But
So
later he found that it was wrong, his retirement.
accordingly, I have approached
Okay.
the honorable court, and he was enjoying fixed pay, and he was regularized later on. So
His standing
I
is
don't know how
different.
he was regularized. Why? Because they were on same footing, my lord. All these five
Is
petitioners
this
in the
three
petitions.
is also a petitioner?
No, he's
In one
not.
of the
He's
case,
not.
my lord. In one of the writ petitions.
In one
yes.
of the writ
Okay,
petition.
so what
Yes.
He
happens
is
to
one
that
of the
writ?
writ petitioner. Yes, he is one of the.
In which writ petition? In which writ petition?
Uh,
There are 5 writ petitions, no?
Yes, my lord.
In which
Yes,
writ petition?
which one?
Lordship,
Writ petition
102, page 14.
102, no?
Yes, yes.
So
We are not filing against this appeal.
this appeal is not against this
Yes, yes.
102.
Yes.
Okay.
Only in respect of number 1, 0, 1, 2, 4, and 5.
1, 2.
4 and 5. Yes.
So this man is still continuing in service.
Lordship, for that, I don't know whether he retired or. But I've been told that.
102.
Yes, yes. His service was regularized. Yes.
Okay, his service was regularized.
Yes, yes.
Okay. So, Mr. Likase,
Yes, my lord.
inadvertently you had actually brought this man.
No, my lord. Actually, the petitioner in 102, he has received the release order given by the office, my lord. And that's all. Accordingly, I proposed this.
No, but he has been regularized even before it's released.
No, my lord.
He was not regularized in service.
Actually, my lord, he was given the release order. Release
But
order.
it was wrongly given.
And
So just that release order was recalled.
That too, I do not know. But your lordship, he was wrongly given mention that he is supposed to release from such and such date, and the department found that he is supposed to continue. So they can let him continue and they regularize his service because he can't.
They regularized his service.
Yes, yes, yes. They regularized his service after the disposal of the writ petition, lordship.
But my lord, till now, that very petitioner in 102, he has not received any regularization order.
Then he is supposed to approach the department.
No, but he was given release order. So he is assuming that he has been released from office. Why? Because like his release order has not been recalled, nor he has been informed anything about it.
You at least leave aside this poor man. If not, the impact of this order will negatively affect
Yes,
him.
yes. May I listen, my lord? My lord,
Yes,
may I take the lordship to...
Anything more from, huh? Okay, if any query, we will ask you again.
My lord,
So that's all for
Yes,
madam.
yes, lordship.
That's all for you. Yes, you justify the learned single judge order.
my lord, I sought for relief on 2 grounds. That is CCS benching rule as well as on the order of the learned single bench, my lord. But in the earlier occasion. Here, my lord, may I take your lordship to CCS benching rules once again, my lord, page 21.
Page 57.
Page 21, my lord.
CCS pension rule is on page 57.
57. My lord, here, my learned friend has given only the half portion of the text. So I'll take
Okay.
you to the
Page,
where the whole
Page?
text has been given.
page,
My lord, page 11, my lord. 20, my lord. Page 20, para 11, my lord. Yes, first portion is already read out by my learned friend, so I'll take your lordship to the second part of the text, my lord. That is page 21.
what is,
Page 21. my lord.
what is this? This is a part of your WPC.
Yes, my lord.
think we should.
Second part, my lord, page 21. Terminal benefits, second part, my lord. Second, terminal benefit, my lord.
Terminal benefits?
Yes, my lord. Terminal
Just wait.
benefits, one.
Just wait. Here's what it says.
My lord, quasi-permanent and temporary employees who retired on superannuation or on being declared permanently incapacitated for further government service by the appropriate medical authority after having rendered temporary service of not less than 10 years shall be eligible for grant of superannuation, invalid pension, retirement gratuity, and pension benefits and at the same scale as admissible to permanent employees under the CCS Pension Rules 1972, my lord.
It is not applicable to you.
Yes, my lord. This covers my case, my lord.
No.
Yes, my lord. And here in the first portion of the CCS Pension Rule, my lord.
Are you a quasi-permanent? Are you a temporary employee?
Yeah, my lord. As per the definition, which means servant should be eligible for being declared as quasi-permanent if he has been in continuous government service of more than 3 years, my lord, in a department against the permanent.
The only issue is that you are not a government servant.
My lord, I am my lord.
You are a fixed pay employee.
Fixed employee, but
yes, it is only when actually you are regularized as per the scheme, you become a regular government employee.
My lord, I'm a government servant, my lord. Yes, my lord. No.
There are 101 Supreme Court ruling, which says that actually there's all this a fortuitous appointment and they cannot be termed as government servant to enable them to avail the benefits of Article 311 of the Constitution.
Yes, that's it, but as per the government retirement employee act, you
are not in a pensionable service.
Yes, madam.
As per the retirement act, you are not in a pensionable service. And the retirement act is applicable only for those who are in a pensionable service. You are not in a pensionable service.
But I'm being released as per the act of that.
Only once you were regularized as per the scheme,
yes,
you become a government employee entitled to pensionary benefits. Till then, you are a fixed pay employee.
Yes. My lord, dear, I'll take your lordship to page number 26 and of the appeal memo, my lord, office order, and that is my release order, my lord. May I read, my lord? Page 26. Office order, my lord. In terms of section 3.1 and section 3.2 of the Nagaland Retirement from Public Employment Second Amendment Act 2009, which comes into effect from 31 October 2009, and in terms of government and Nagaland PNAR Department of so-and-so, dated so-and-so, she so-and-so, labor code number so-and-so, is hereby due for retirement on condition of 35 years of length of service verified from so-and-so. So, my lord, this implies that I'm...
No, it does not give any implication. It does not give any implication.
And here, the second ground which I've taken is that the relief that I saw is when the order passed by the single-landed bench in WBC 96.
Which page?
96. 30, my lord.
Page 30.
Yes, my lord.
What is,
This is the order which I have relied upon, my lord.
yes,
And here, the case of the petition has been considered, my lord.
I know this is single bench, we are not bound by
Yes,
it.
my lord.
You have seen that Nishevi's case decided by the Supreme Court. You have seen this case which is decided by the Honorable Division Bench,
Yes, my lord.
where they have,
And my lord, I was informed that in the case of Nishibi, I was informed that the respondent in the civil appeal, they have approached the Supreme Court and it's pending before the Supreme Court.
okay, it's all right. Pending if suppose, if in review, the Supreme Court reconsiders the judgment, we can give you that relief, but as of date.
So just point out one thing. You come to page 37, which you have just noted, single bench. Okay, page 37, which you just said now, single bench. If you read the last third line, 1, 2, 3, fourth line, okay, it just says that it is also made clear that any decision taken by the respondents. So it doesn't say that you have to appoint, it's any decision. So it can be either regularization or not. See, it's still left to the discretion of the state government. It doesn't say that you have to give him pensionary benefits. So the last line makes it clear that it is the single bench is not directing the state respondents to do anything. It is just left to the discretion. Any decision taken, so it has left the discretion to the state government, isn't it?
There is no mandate issued by this court to give appointment or to give pensionary benefits. There is no mandate. It is only to consider. And even otherwise, there are so many cases, single bench, which has actually directed the government to consider granting pensionary benefits. But in view of the case, the decision in Nishevi's case and this recent division bench judgment, we cannot take a different view.
We are sympathetic. We can imagine the plight of the employees, but what to do if the law doesn't permit? No. That's the
My
problem.
lord, here in the case of Nishibi, the grounds for
2004 notification is there. Nishibi, what to do?
allowing the appellant is that they have approached the court after
For
a
review.
delay of more than 12 years.
That is just one ground. That is just one ground.
Yes.
The other ground is that he was not the senior most. You are not the senior most. And again, 2015 notification.
My lord, when I'm retired, how can the state respondents say that I'm not a senior most? When I'm already retired?
Mr. Likase, you should understand that there are thousands of work charge employees in the various establishments of the government. So out of this 1,000, the unfortunate hundreds goes on retirement without regularization and pensionary benefits, because there is actually no vacant post, no sanctioned post to accommodate these persons. And likewise, like you, so many hundreds of the work charge employees, after serving for 30 years, after retiring after 30 years by age and 35 years by service, they have all been allowed to go without regularization, without pensionary benefits. So, and one thing is that when actually you are not in a position to be regularized in service during the tenure of your service, after retirement, how can this court issue a direction to reinstate you for pensionary benefits? When you were not eligible during your service career to be regularized. After retirement, where is the question of this court giving a direction to regularize you in service posthumously or retrospectively for pensionary benefits? That will be against the decision of Uma Devi. There are 101 Supreme Court, Honorable Supreme Court's decision. which says no posthumous regularization, which says no retrospective regularization. Now, if we allow you posthumous or retrospective, we will be going against the law laid down by the Supreme Court.
My lord, just one Supreme Court order which I would like in the case of Talsipan.
That Gujarat's case.
Yes, ma'am.
Gujarat's case, actually, the fact situation may be different. Because the most relevant and the nearest case to us is Nishavi's case, which is decided on the basis of 2004 OA. And the fact situation is different. Maybe there it was ad hoc appointee, who after serving for 35 years was directed to be regularized for pensionary benefits. Here is a question where actually whether you are eligible under the scheme or not. That has to be considered.
My lord, dear, in the RCPI 2004 OM, it was the status one who has to take care of the employee.
State respondency. Don't shift everything on the state, because actually you are the petitioner, you are supposed to actually satisfy this court about your case. You are saying state government, but the state government says that actually you are not the senior most. So at least while filing your writ petition, you should not have filed casually. You should have brought all the material saying that this is the seniority is maintained in the department. Up to this seniority, they have been regular. Whereas actually when my turn came, they have bypassed me. They have instead appointed my junior, regularized my junior. You should come with all the facts and materials.
My lord, it's out of record, but in the department, seniority is not maintained.
Well,
they are maintained as per the district wise, so it's very difficult for the petitioner to receive the correct document.
You may
That's
be right.
how-
You may be right, but at this juncture, we cannot actually take your submission, take the face value of your submission. So what to do? We are not actually coming on your line, unfortunately. Though, as Madam has said, we want to help you. We are very sympathetic with you, but we have to go by law.
Yeah, because of this an issue as well as the reason division.
And in this kind of cases, irrespective of whether there is that Nishavi's case or not, Uma Devi squarely covers it. And there is one Manipuri case, I think Manipur case, which very, very clearly states that if you are not entitled to be regularized while in service, the question of regularizing you after retirement for pensionary benefits is impermissible. The Supreme Court has laid down that law also. And that is in, I think, in one Manipur case. So when all these things are binding on, all the laws laid down by the Honorable Supreme Court is binding on us, we cannot squeeze out.
So we have to allow the citizen.
I think we need to just
Make it a
think.
CAV.
Yes, think over and then I'll, yes, or you will, yes, you will be traveling.
Yes, I'll be traveling.
Yes,
We'll make it
because
a
I think
CAV.
facts, we need to grasp some facts.
Yes, yes.
I thought we will just dictate here, but I think maybe there are some facts which we have to differentiate between.
Yes, yes.
Okay, so we keep it CAV.
CAV.
And then make everything in that side.
Okay, fine.
Heard. MS V. Sokri, Learned Additional Advocate General for the State Appellants, and Mr. Likase Santam, the Learned Counsel for the respondents. The parties at length, judgment reserved. Okay, we'll pass judgment, but I think we have already expressed our mind.
Unless there's something else which we missed.
Okay, man.